Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friend. Hello. Today is Thursday, March 6th, and I want to thank you so much for coming to hang out with me for a little bit of time today. We have for you today an arraignment for Aidan Kearney. Yesterday, we were live for 6 hours on the Karen Reed hearing, which I'm still spun about and exhausted over. My everything is exhausted. And while we were live on that stream, we learned that some new charges had been brought against Aidan Kearney. And they discussed them yesterday during the hearing. There's finally some video of yesterday's hearing, and I'm going to play for you what happened at the end of yesterday's hearing, because many of you brought to my attention that there may be new charges against him. So let's listen to Cosgrove, who's the special prosecutor on this case, talk about these charges. And then I have the Zoom up for what is supposed to be the arraignment today. And this is again, and I guess Norfolk Superior in front of this same judge. Let's hear. The audio is a little bit low, so I may need to adjust mine. Just let me know.
Next scene, please. Oh, yeah. Let me just, I talked to the lawyers at Satire for a minute. Maybe over here. Mr. Cosgrove, the floor is yours.
Yes. Your Honor, I can just take a moment.
Did. He looked in the window of D&E Pizza because he was at CF McCarthy's the other night. And here's what Cosgrove has to say about it.
This morning I was informed that there was an incident last night. Apparently the defendant and a friend were at CF McCarthy's, which is a bar in Canton. It's next door to D&E Pizza, which is owned by one of the witnesses in this case, and his son, who is also a witness in this case, and I should
So I guess it's Chris Albert and Colin Albert.
say they're witnesses in the Karen Reed case, works there, and they are both victims listed within the indictments that are before your honor. At the end of the evening, the son closed up at D&E Pizza and went home. There is a video camera, possibly more than one, but one in particular in the window of D&E Pizza. And what it recorded was that Mr. Kearney left C.F. McCarthy's next door, and in the company of a friend or shortly joined by a friend, walked up, either noticed or had previously noticed the video camera, and walked up to the window quite close, pressed his face up against the window almost, and then stepped back for a moment or two. Spent a couple of minutes just staring there, and then went into a 2-minute diatribe.
Objection. Diatribe. He's categorizing it as a diatribe. I don't know. I have no idea what he said or did, but it's a diatribe according to Cosgrove.
Saying hello to the witness. What have you done? I wish he was alive today. Why did you do that, Chris? He's talking to Chris Albert, the witness. I just want to know. Then he goes on to say, and I have to paraphrase from here, Your Honor, because I didn't get it all down in the brief time that I viewed it. But I know you didn't do it. Colin did it.
Colin did it? Colin did it? Hold on a second. Gotta hear this again. Because it's funny. It's not funny for Aidan, but I think he can appreciate we're not laughing at him, we're laughing with him, because this is what Colin did it. We need a colon cleanse. Colon cleanse on line 3. I think there was a Curb Your Enthusiasm about that, an episode about that colon cleanse. Anybody remember that? All right, listen.
Didn't do it. But I know you didn't do it. Colin did it. And then he goes on essentially to ask why he is covering up for his son, assures him that he's not trying to frighten him. He just wants to know. Just wants to know. Now, at that point, he walked and went away, leaving Mr. Albert to find that the next morning when he reviewed his video.
Was he intimidated by it? Curvaceous XOXO says, are you sure it wasn't semicolon? Watch Bederow's face here in the lower left portion of this video.
We can talk about how many legal angels dance on the head of a pin here, Your Honor. I think I could do Mr. Brown.
How many legal angels do dance on a head of a pin, though? Can someone, Google that and find me the answer? How many legal angels dance on the head of a pin? I don't know. I think I might need to steal that. We need shirts, Tracy. We need shirts.
Bradl's argument for him. It's just speech.
Oh yeah, here's where he says, I don't want to make Mr. Bradl's argument for him, but now he does make Mr. Bradl's argument for him. I don't know. Do you think Cosgrove is even embarrassed to have to get up in open court and talk about this Pizzagate issue?
Angels dance on the head of a pin here, Your Honor. I think I could do Mr. Bradl's argument for him. It's just speech. Nothing's meant by it. It's protected. I doubt I've saved him the trouble, but I've tried.
Well done to you, sir. At
this point, I don't think it's an issue whether technically it meets the standards of intimidating a witness. I think certainly the attempt, at least in the colloquial sense, was to harass and intimidate. And we always talk about these in isolation, Your Honor, but there is a drumbeat every week of verbal attack after verbal attack.
Bang that drum. What part of Lally's body is banging that drum? Remember we call him the one-man band from the Karen retrial? If you're just tuning in, welcome. This is from yesterday, so we're not at the live arraignment yet. That's supposed to start at noon, and I'm in the Zoom room. It says courtroom 1. I'm in courtroom 1's personal meeting room. I hope I'm in the right place. Thank you, Suze, for sending me the login info. Lally was the one-man band of the Karen retrial. He had cymbals between his knees. He had a harmonica in his mouth. He had a horn one of those clown horns underneath his armpit. Maybe he could carry the drum around his neck and then use his hands actually when he's not playing the accordion to beat the drum.
Every week,
Every
a
week.
verbal attack after verbal attack on the witnesses and the officers in this case. So at this point, I am going to ask the court to set bail on Mr. Kearney. He's been released on his personal recognizance.
This is from
And I
yesterday.
am also going to ask the court to set conditions. And those conditions will be no contact, direct or indirect, or through third parties. And I mean no contact in the broadest possible way with any of the witnesses or officers testified for the Commonwealth in the Reed case or any of the alleged victims in this case. And I am going to ask that Mr. Kearney, as a condition of his release, be prohibited from approaching anywhere within 100 yards of a victim's residence or within 100 yards of a victim's place of work.
So he can't go within 100. They want him to not be able to go 100 yards within D&E Pizza. But what if he wants to have a meal of food at the CF McCarthy's? Because that's what he was doing. Isn't that like the length of a football field? Like that's pretty far.
Okay, thank you. Mr.
Thank you very much, Judge. Judge, this is not how incursions of someone's liberty are done in Superior Court or in any court that I know of in the Commonwealth of Massachusetts. I don't have a shred of paper. I don't have a shred of documentation. I don't have anything on this issue.
You want to continue? I'll give you one.
Yes,
I mean,
certainly.
look at it.
Yes,
You
absolutely.
want to come back tomorrow?
I don't think I can come back tomorrow, Your Honor, but you know, the government should be sent out to go get their ducks in a row. No pun
Yeah.
intended.
I love him.
Maybe we
Then
could
if you
borrow
have-
Mr. Kearney's.
I love him. Because earlier in this hearing, and we'll watch it after we watch today's hearing, if you like, he talks about Rich Schiffer and the rubber ducks and the 36 or 32-page police report. So I like how he circles back and brings ducks back into the hearing.
If they have an issue, then they should come back for it. But you don't say, hey, I heard this thing happened and
Why
I
don't
want
I
to.
do this? Why don't I do this? I'll give you 24 hours, Mr. Bradl. You absolutely have a right to review the video and you have a right to see any reports that were written. I'll see you both back here at 2 o'clock tomorrow. Does that work, Martin?
I was going to suggest noon.
How about noon tomorrow? Does that work?
That's fine, Your
reasonable.
Honor, and I don't mean to prolong this unduly, but I just want to say I became aware of this incident that happened last night at 10 o'clock this morning.
That's fine.
So
And that's great, but the government should do some investigation and, give me a chance to say
Yeah,
something.
we'll address it tomorrow at noon.
That's great, but the government should do some investigation and maybe come in here with a piece of paper for me. How about a piece of paper? How about something? We got papers. We got the papers. We're going to look at them.
In the meantime, Mr. Kearney, just stand up, stay away from that pizza place, okay? What was the name of it?
it's,
Like he
I'm
doesn't-
sorry, Your Honor.
like he doesn't know.
It's D&E Pizza.
Okay, just stay away from that and then we'll address it tomorrow, okay? All right.
So the matter is continued to March 6th at noon. Mr. Kearney, you are ordered to stay away from D&E Pizza. Do you assent to this condition, sir?
Yes.
And you're hereby notified if you're charged with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58.
Okay,
Thank you.
thank you all.
Thank you, Your Honor.
Now, Mr. Kearney, you stay away from that pizzeria. You hear? You hear? You stay away from that pizzeria, Mr. Kearney. All right, well. Any of you, I think some of you might have been actually in the courtroom yesterday. I heard that I heard that they were outside the courthouse and they would not let anyone in. Hey, Skybell, thanks for becoming a new member. Thank you to Tracy Walker for gifting 5 memberships. I appreciate you. As always, Sylvia W., Tracy Walker herself became new members. Welcome. And then Tracy gifted another 5 memberships. Tracy has been gifting memberships all over creators that are covering Karen Reed, and she is incredibly super generous. So let's all give Tracy Walker a big thank you, a collective thank you. Thank you so very much. Mama She is here and says, oh, you got your merch yesterday. Woohoo! That's awesome. Do you like it? Was it good? I don't know what you got. Because it shows me the orders that are made. It doesn't say who ordered what. Obviously, it doesn't give me your address or anything like that. But I wonder what you got and do you like it? Is it good quality? Leslie's Google search, not. So Massachusetts is going after free speech. Oh, yes. I'm sorry. It's been going on for quite some time. Yes. Yes, absolutely. Their whole entire witness intimidation statute is designed to curtail free speech because if you hurt someone's feelings in Massachusetts, it can get you a felony witness intimidation charge. But here's the thing, they only selectively prosecute this statute. So there's only certain people who are charged with this statute. And most of the people that have ever been charged with this statute are all people who do not believe that John O'Keefe was hit by a car and that a car did not hit John O'Keefe. Isn't that interesting? Isn't that interesting? I would love to know if that statute has ever been persecuted before in the state of Massachusetts. If you know, let me know. Kelly's here and she gifted 5 memberships. Thank you so much, Kelly. And welcome to all the new members. And Jeep Hers became a new member. Amelia Walsh says Bederow's faces are brilliant. Wonder what Bev will think of them. This judge is so lovely, in my opinion, from what I have seen so far. Yes, I like him too. He seems to get it. If you guys want to, we can watch the whole entire motion to dismiss hearing because now it is up. Now it's up and the video is up. But yesterday they muted the Zoom so nobody could watch it over Zoom. And so that's kind of crazy, right? Yeah, thank you. I finally found the settings on my new camera, so I was able to adjust the white balance, which is why I was looking so pale. In all of the previous couple of videos that I did, I'm like, why am I looking so pale? There's got to be settings on this new camera. I finally found them. It's AI generated. That was part of yesterday's hearing, but today we are going to watch today's hearing, which is why the Zoom is up on the screen, which is why we're waiting for it to start. And so, yes, I have the hearing. We may watch it. Thank you, everyone. But since we're waiting for it to start, is anybody in the courtroom? That is also in the chat. Okay. I mean, there is one portion of the statement of facts that has published on the court website. So while we wait for the Zoom to start, why don't we take a look at that? Haven't even had a chance to redline it yet. And we may have to switch right over to the Zoom. We may get interrupted, but let us take a look at this. How can we best do this? No, it's wicked. It's wicked small. The font is wicked small. Maybe if we go like this, and like this. Take that down, move me over here. This is a statement of facts in support of an application for a criminal complaint. This is the only page that posted. It says page 1 of 2, but this is all we got. That's all we got. This is in Stoughton District Court. It says Kearney, Aidan. On March 5th, 2025 at approximately 08:15 hours, I spoke with Christopher Albert. Now he's Christopher. Chris Albert is a witness in the open Norfolk Superior Court case of Commonwealth versus Karen Reed. Reed is charged related to the homicide of John O'Keefe on January 29th of 2022. Yes, he's being wrongfully persecuted. That much we know. So thank you so much for that. I got to get my red pen ready. Oops, I was redacting stuff, so it's too thick. Hang on. Hold, please. On March 5th, 2025, at approximately 08:15 hours, I spoke with Christopher Albert. Chris Albert is a witness in the open Norfolk Superior Court case of Commonwealth versus Karen Reed. Reed is charged related to the homicide of John O'Keefe on January 29th of 2022. People are now going in. Okay. I have it up on my other screen. Don't worry. We won't miss it because I'll hear it when it starts. The first criminal trial in the spring of 2024, where Chris and his son Colin Albert testified, resulted in a mistrial. The retrial is scheduled to begin on April 1st, 2025 in Norfolk Superior Court. Reed's defense attorneys have alleged a massive conspiracy to frame Reed and have stated in written pleadings and in open court that Colin Albert is responsible for the death of John O'Keefe and Chris is aided in the conspiracy. I'm going to say, I don't know who wrote this. We'll find out at the end, but I don't really think that they're saying it was a massive conspiracy. Massive? Okay. We'll see who wrote this. Beginning in April 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on the civilian witnesses, members of their family, and their friends. Kearney authors and publishes a blog on the website tbdailynews.com. The website has a series of articles entitled Canton Cover-Up. In October of 2023, I arrested Aidan Kearney. Oh, who's this going to be? Who do you think wrote this? Who arrested Aidan Kearney in October 2023? Because you know what? We don't have page 2 of this. Was it Tully? Tully. I arrested Aidan Kearney for witness intimidation resulting from his harassment of police and civilian witnesses in the Reed investigation. Kearney was later indicted on those charges. Colin and Chris Albert are named victims in Kearney's open case out of Norfolk Superior Court with this index number. Both Reed and Kearney's criminal charges have been the subject of nationwide new coverage. New coverage is new, not news, new coverage and constant internet fodder. Well, there's nothing like adding your personal opinions into your police report, Tully. But could we expect anything less? Chris sent me emails. Oh, Chris is emailing him directly. This is interesting. Was it to his personal email or to his work issued email? I want to know. Chris sent me emails with 2 videos attached from March 4th of 2025. Okay, but did he call you first and did you then say email him? Does he have you on speed dial? We know Chris Albert tried to get a restraining order against Aidan Kearney and that was denied. That was denied. And you remember because Michael Marcy wrote some emails to all the Stoughton district judges, including Judge O'Malley, who did not issue Chris Albert a restraining order. And in his email to those judges from his private email server, he attached a screenshot of a text message from Jennifer McCabe that said, "Hey, I know it's late, but I can't believe that Chris didn't get it." We see what's going on here. The world is watching, and we've got really big eyes. We are the eyes of the world. The videos are from Chris's restaurant, D&E Pizza at 618 Washington Street, Canton, Mass, depicting Aidan Kearney. One video depicts Kearney walking down the sidewalk from the direction of CF McCarthy's, which is located next to D&E Pizza at 614 Washington Street, Canton, Mass. A group is seen leaving CF McCarthy's that later joins Kearney. Kearney stops in front of D&E and places his face next to the front glass window of D&E. An interior camera captures Kearney standing close to the glass, staring into the camera for approximately 25 seconds. You know, I bet that was really intimidating. Do you think? A male with the group that exited CF McCarthy's joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute, still photograph attached. Audio is captured by an exterior camera. The sound of the occasional passing motor vehicles obscures the audio, but I can discern the following statements made by Kearney. Oh, that's interesting. So you can't really hear it, but you could hear only these certain portions of it. That's interesting. Did you use CapCut to edit your video or the little drop-down menu that we saw yesterday in open court when Brennan put some video up on the screen of the Sally Port? AI? Who knows? Quote, "Hi, Chris. What have you done? Murdered. Misses you. Wishes he was alive today. He would be. Why did you do that, Chris? Chris, why did you tell the jury that you got home? Why did you say you went upstairs and then waited 15 minutes? Then Colin came home. Colin didn't make it home until at least 12:45, Chris. It was Colin, Chris. I just want to know. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why. Colin did it. You can tell me. Oh, Colin did it. See? They had to put that in there, even though maybe it doesn't even say that. Maybe it does. I don't know. But, that was on what was on the bottom of the little rubber duckies. Colin did it. But that wasn't Aidan Kearney's charges. Those are Rich Schiffer's charges, which were later dropped. See? You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. I don't want to scare you. See, he doesn't want to scare him. His mens rea was not to intimidate. Tell Jill to keep their hands to herself too. Jill Daniels is his wife, Julie's sister, I believe. Yes. And I think she's in I think she has some charges against her for maybe assaulting him. I'm not quite sure on that. The statements made by Kearney and his conduct of standing outside D&E Pizza is the same conduct that was the basis for his indictment. The statements and his conduct of standing outside D&E Pizza. Okay. Kearney directed his statements into a camera that he knew would be seen by at least Chris Albert. I'll just check the Zoom feed because, okay, it's not ready yet. Kearney directed his statements into a camera that he knew would be seen by at least Chris Albert, a named victim in his pending witness intimidation case and a witness in the Commonwealth v. Reed. When Chris saw the video, here, Zoom's coming up. I just heard myself on the Zoom and I wasn't muted, but they've muted me. Hold on. The judge is not taking the bench, so. And it had me saying, when Chris saw the video, which is, I guess, where we left off. When Chris saw the video shortly after the incident, he became upset. He became upset. See, that's the key there. But if he becomes upset, it's witness intimidation. He stated he is upset for his son, Colin, and the possibility that Kearney would continue to come to the restaurant to confront him or his son. On March 5th, 2025, Kearney is scheduled to appear in Norfolk Superior Court at 2 p.m. for a pretrial hearing motion to dismiss. Kearney's on bail on the Norfolk Superior matter involving intimidating Chris and Colin Albert. Due to the continued and the seriousness of the intimidation at Albert's place of business on the eve of a consequential court date, I respectfully request an arrest warrant be issued. That's what they want to do. Hang on.
Superior Court, we just ask you remain on Zoom during the hearing. Thank you.
Can you hear it?
Yes, I guess I muted him.
Can you guys
I thought I
hear?
was being so true.
All right.
Ooh, my own. Ooh.
For the record, before the court, numbers 4 and 5, Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43. Mr. Kearney is present, along with his attorneys, Tim Bradl and Mark Bederow. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for a bail hearing. If the parties could please identify themselves for the record.
Good morning, Your Honor. Robert Cosgrove for the
Hi,
Commonwealth.
Mr. Cosgrove.
Hello, Your Honor. Tim Bradl on behalf of Aidan Kearney to my left.
Okay.
Your Honor, Mark Bederow for Mr. Kearney.
All right. Good afternoon, gentlemen. You can be seated, Mr. Cosgrove. I've seen the video. Go right ahead.
All right. Well, thank you, Your Honor, for hearing us today. I have a couple of things that I would like to do. Your Honor has seen the video. I want to put some observations about the contents of that video on record, and I want to draw on the police report, a copy of which I have provided to counsel. I'm going to read excerpts from it that I think are significant because aside from summarizing the contents of that video for the record, they also summarize somewhat the reactions of the Alberts upon viewing that video. Lieutenant Tully's report would indicate that at approximately 8:15 in the morning yesterday, he spoke with Chris Albert, who, as Your Honor knows, is a witness in the open Superior Court case of Commonwealth versus Karen Reed. Yesterday in the presentation, I referred to a number of incidents which Mr. Kearney was indicted for, which the Commonwealth alleges constituted intimidation of the witness with respect to Mr. Albert and with respect to his son and to other witnesses in this trial as well. And I made reference at that time to the videos, which I believe you have been provided by Mr. Bradl in his filing that were played before the grand jury that record some of the background. And I think that's important, Your Honor, because if we're talking about, to draw an analogy, Chinese water torture, it's not the current drip, it's the accumulation. And I think whatever one thinks of this video, it has to be placed in that context. Lieutenant Tully continues that Mr. Chris Albert, who I will refer now to avoid confusion simply as Chris, sent him emails with two videos from March 4th. They're from his restaurant, D&E Pizza, on 618 Washington Street in Canton, depicting Mr. Kearney. One video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is located next to D&E Pizza at 614 Washington Street. And a group is seen leaving C.F. McCarthy's that later joins Mr. Kearney. Mr. Kearney stops in front of D&E and places his face next to the front glass window of D&E. And an interior camera captures Kearney standing close to the glass, staring into the camera for approximately 25 seconds. A male with that group then exited C.F. McCarthy's and joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute. The audio is captured by an exterior camera. The sound of occasional passing motor vehicles obscures the audio, but Lieutenant Tully could discern what he describes as the following statements made by Kearney.
It's Tully.
And I pause at this point to put on record what the court already knows, which is that subsequent to the Lieutenant Tully's composing this report, we made efforts to merge the two videos into one video and to enhance the audio. So that is what Your Honor was presented with. The videos themselves were not changed in any way, but they were merged. So essentially you see them both playing at the same time, and you hear an enhanced audio, which in my view is still not great. As Lieutenant Tully heard it, Mr. Kearney said this: "Hi, Chris, what have you done? Murdered. Something's inaudible. Misses you. Wishes he was alive today. He would be. Why did you do that, Chris? Chris, why did you tell the jury that you got home?
Love his dramatic
Why did you
reading.
say you went upstairs and then waited 15 minutes? Then Colin came home. Colin didn't make it home until at least 12:45, Chris.
Colon.
It was Colin, Chris. Colin. I just want to know why Colin took so long to get to your house. Why,
It's gonna
Chris?
be played everywhere.
Please tell me why Colin did it.
Why
You
Colin
can tell
did it.
me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands up to herself, too. Those are the statements he made in his conduct standing outside D&E Pizza. Similar to the conduct that was the basis for his indictment. And Your Honor has probably viewed at this point the video of the defendant standing outside D&E Pizza accusing both of these parties of murder.
Yeah, what?
When Chris saw the video shortly after the incident, he became upset. He stated he's upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him and his son.
Do you think Turtleboy is
And that's
laughing his ass
basically
off right
the
now about
report,
Colin?
Your Honor. Your Honor, there are two Aidan Kearneys. There is the courtroom Aidan Kearney, as is presented by counsel. Is careful only to exercise his First Amendment rights, and in no way does he have anything to do with the things that have happened continuously to the victims in this case as a result of his continuing broadcasts and other activities that have continued since his indictment. If Jennifer McCabe is getting anonymous letters threatening her, Your Honor,
What?
with having her head chopped off in prison,
That's not part of these charges, Cosgrove. Really?
if her daughter's school is getting phone calls and letters
That's Aidan's fault?
asking her professors if they knew they have sitting in their class a daughter of a murderer.
Oh, I can't wait for Bradl to get up.
Mr. Albert is getting phone calls. If people are photographing him on the street and sending those photographs when he's trying to enjoy his dinner or he's at the beach to Mr. Kearney, who posts them.
Okay, your objection is noted. Go right
He's
ahead.
photograghting
Mr.
everyone outside his
Go right
pizzeria.
ahead, Mr. Bradl.
He's photographing
who
everyone that
posts
walks
them
by his
on the
pizzeria.
internet.
He's not
That
going to
has
shut up.
nothing to do with him. He's only responsible for his own conduct. Your Honor, a few days ago, Mr. Kearney was standing outside this courtroom waiting for a Karen Reed hearing, which he was covering in his supposed role as a reporter. As he went up, he was filmed by another one of the Karen Reed supporters. He was filmed for a, quote, live show by Tom CPU. He's a Reed supporter and a YouTube personality. And this video of Mr. Kearney's interview was subsequently posted on one of the free Karen Reed video shows.
Tom CPU has
I
a
watched that
chat.
video, and I wrote down what Mr. Kearney said just about 2 weeks ago. It was brought to his attention by the interview and in a friendly way that word had leaked out that all of the threatened actions by the U.S. Attorney's Office, which the witnesses in this case have been threatened with, they're going to be indicted, they're going to be marched to jail. District Attorney Morrissey's phone is being tapped. The police are corrupt, they're all going to be indicted. That investigation, if it ever was an investigation, it concluded with nothing, zero, nada.
Nada.
Kearney was asked about that, which at that time was a rumor. And here's what he said. They all know what they did. It's just so obvious. Like I said yesterday, if they are never charged, okay, they got away with murder. Congratulations. They got away with it. But I have successfully made it. So no matter where they go in public, if they walk into a restaurant, the people will always look at them funny and they will be like, oh, there's the people that murdered John O'Keefe. When they walk into a restaurant and they look around them, they have to be thinking, who here thinks I'm a murderer?
Well, that's not Aidan's fault, though. That's not Aidan's fault.
Judge, I object. I move to strike. Counsel, is he counsel for the Commonwealth? Is he a witness testifying? I have no notice of any of this stuff. What's going on here?
Okay,
I have
your
no
objection's
paperwork.
noted. I'll hear from you, as I said earlier, Mr. Bradl.
What's going on here?
Go right ahead. Mr.
Sigh
Cosgrove,
emoji.
what's your recommendation?
Sigh
What do you
emoji.
think?
My recommendation.
You want to put him in jail?
My recommendation, Your Honor, is one, that the court enter a stay-away order with respect to any property in which any of the witnesses in the Reed case for
Any
the
of the
Commonwealth
witnesses?
or in any of the pending indictments against Mr. Kearney. And that stay-away order require him to remain a distance of at least 100 yards from any of those locations. My second recommendation
witnesses.
is that the court enter an order with respect to all of those same people, the witnesses in the Commonwealth in the Reed case, the witnesses in all of the currently pending indictments against Mr. Kearney, that there be no contact with any of those victims, direct or indirect, through a third party, by any means whatsoever.
I can't wait for them to get up and post
And I
this.
hesitate, given my own respect for the First Amendment,
Do you have respect for the First Amendment? Because you're asking
to
for
make
something
any
that-
recommendation as to what Mr. Kearney can say. However, I note that to accuse someone of murder,
we are in the
accuse
Twilight
someone
Zone.
of murder is defamation per se. It's a tort. It's not the only tort that Mr. Kearney has committed along the way. There's been invasion of privacy. There have been others.
Torts are handled in civil court, just
A
FYI.
witness can come to me and say, what can I do? What can I do to stop this? I didn't sign up for this. I agreed to testify. I answered your questions. I agreed to go into court. I agreed to be cross-examined, redirected, challenged. I didn't sign up for 2 continuous years of shame.
Neither did Karen Reed. And it's been 3 years for her. And over
Now, I
$5
don't know
million.
what I do, Your Honor. I don't know if I say to them, well, I'll tell you what. Get yourself over to the civil court, file a civil suit. You get a pretty good defamation case against Mr. Kearney. And after you pay a lawyer $10,000, $50,000, whatever the going rate, maybe you'll find somebody to take it on contingency. And after you've been deposed, and after you've sat in court and been to court a number of times, and after there's a trial, you might collect a pretty handsome amount of damages.
You'll never be able to collect
That's going to
it.
be 2 or 3 years down the line. But I am helpless, Mr. Witness, in a criminal case. Remedy. I think that's all just First Amendment stuff. That's not intimidation of a witness. I'm not sure what I do, Your Honor, but I'm going to ask you also to set a condition that there is to be no defamation of any of these witnesses. Finally, I'm going to ask you to set some bail in this case. I was not involved in the case. I understand a request for bail was made originally, and for some technical reason, it was not allowed. And I acknowledge that Mr. Kearney, since he has been indicted, has been faithful about showing up to court. I have no reason to think that he will not show up to court in the future.
So then why does he need bail?
I think he regards it as another opportunity to put on the Aidan Kearney show outside.
The Aidan Kearney show, first of all.
But I do know that he's facing charges that carry substantial penalties, that are felonies, and that if a jury should see it my way after trial, I put the defense and the court on notice that I see his conduct since these indictments have been brought as aggravating circumstances, and I will certainly take that into consideration if I ever have the opportunity to make a sentencing recommendation.
You're not the
I
judge,
would suggest
sir.
what
You're
would
not
be
Cosgrove.
a nominal bail, 10,000 surety, 1,000 cash, but pray your honor's judgment in that respect.
Okay.
If I could say just one final thing.
Go right ahead. You go right ahead.
Make your record, counselor.
I think I'll think better of it, Your Honor. Mr. Bradl can bring to the court's attention what I was about to tell him if he wishes, and I will not get into discussions with counsel.
Okay. Mr. Bradl.
Thank you very much, Your Honor.
Kurt, I have no idea what time I'm ending.
A procedural objection. There's no paperwork before the court. There's nothing supported by affidavit. I'm just hearing counsel's recommendations right now. So I'm responding to this on Mr. Kearney's behalf, basically off the top of our collective heads here. So that's kind of where we're at, and I would just object procedurally. Nonetheless, we have, a lot we want to say. It's hard to sit here and listen to the Commonwealth with scorn, say that he wants to put on the Aidan Kearney show. Well, yeah, you're darn right he wants to put on the Aidan Kearney show. It's his First Amendment rights to do so. And the Commonwealth, for a year and a half now, has made every possible effort based on their own self-interest. The particular prosecutors, the particular state police detective unit, present prosecutor accepted, to suppress a viewpoint that's been raised against those very same people. So that's what we have here at the outset, Your Honor. As far as this particular motion goes, how far are we going to let the Commonwealth surf this wave? You saw the video. The case at bar, Your Honor, had no stay-away order from Judge Krupp, had zero bail, nothing, not even the stay-away orders, Your Honor. Mr. Kearney was not in violation of anything whatsoever when he did what he did. And in terms of the government, again, out of their own self-interest to suppress his critical viewpoint of them, the government wants to try to tell the court that this is witness intimidation. And as we comprehensively argued and briefed just yesterday, this is not witness intimidation. And the purpose of bail, Your Honor, is not to punish. Under Section 57 of the bail statute that governs Superior Court and Commonwealth versus Brangen, there is no allowance for punishment. Nonetheless, Your Honor, Mr. Kearney has agreed under Section 87 to stay away. And he's agreeing to stay away from the pizza shop, agreeing to stay away from Mr. Albert. But I should say, Judge, again, this goes to how far are they going to surf this wave? Chris Albert and Colin Albert, Your Honor, are no shrinking violets. They're on camera threatening Mr. Kearney, threatening to kick his ass up and down the street in 2 seconds, calling him a pussy. Ooh. These people are not shrinking violets. They're only shrinking violets when they see an avenue to strike out at Mr. Kearney. And now, was it unwise what he did? Yeah, you wouldn't have done it, I wouldn't have done it. Nonetheless, what do you do about it? You don't punish someone, you can't punish them for it. Look at his track record. He's not a flight risk. He has no record whatsoever. He comes exactly when he's called, anytime he's called to answer for this case, and he always will. And he's got kids in Worcester, and he lives in Worcester and Southie, and he's not gonna have any sort of flight risk issues. Nonetheless, under Section 87, Your Honor, we would agree, preserving any procedural objections, we would agree under Section 87, Your Honor, to stay away orders from the witnesses, stay away orders in this case and in the 24 matter as well. However, there's one thing that we're very concerned about, Your Honor, is that there's been a history of these witnesses using these types of orders to flush Mr. Kearney out of court. And we ask that you look at, in terms of an agreement, Your Honor, under 87, we would propose that the court adopt Judge Pomerol's order across the street, which was stay away, but not with respect to courthouses, so Mr. Kearney can do his job, and so they can't abuse any court orders to flush him out of court to stop him from covering these cases. So I would ask that you by agreement, again, allow him to stay 100 feet away from these people. And in terms of courthouses, he's allowed to be in any courthouse of the Commonwealth plus 300 feet curtilage, so he can come and go without accusations, such as we are actually dealing with in another case, Your Honor. But that is essentially Judge Pomerol's order, and we would be agreeable to that under Section 87.
So say that again. Give me Judge Pomerol's order again.
Sure. The gist of it, I'm not saying it's 100% accurate. The gist of it is that he can go, Mr. Kearney can go to any Commonwealth courthouse without worrying about the stay away order, and within 300-foot curtilage, so he can come and go without these accusations that he's violating some order. And that's essentially what Judge Pomerol did, and we are agreeable to that here under Section 87 in light of what's transpired, and reserving the rights, of course, to address this as these allegations as having nothing to do with witness intimidation. There's no threat, there's no fighting words. He's talking into a window at 10:30 at night. And again, you might not do it, I might not do it. Unwise, sure. But what do you do with it? You can't surf this wave for miles and miles here. It's ridiculous. And he's acknowledged it, he's agreeing to it. I ask that you would adopt our suggestion, Judge, and let it be. Thank you.
Okay. Thank you both for your presentations. I'll note a few things for the record. I watched the video. Unlike some of the things that we talked about yesterday that were in the enumerated allegations of the indictments on the 2023 case, there wasn't any camera that was being used by Mr. Kearney. There was no content creation.
Oh, good point, Judge.
I still do have to look at it, I suppose, under the First Amendment and balance that with what Mr. Cosgrove has said about the witness intimidation in the case. I also note that Mr. Kearney has two cases that are pending before this court, and one that's pending across the street, as Mr. Bradl referenced, in the district court. And it may result in a fourth case for his actions the other night. I don't in any way, I've taken a look at his record, which doesn't have much of a record. I also take into account that he has been to court on every single occasion. He's always here with counsel, and my view of him, he's always behaved according to the way that one is supposed to behave in court. So I certainly respect the Commonwealth's recommendation in the case. And what I am going to do is I'm going to make a further order on this case that he's to stay away from all of the witnesses who are enumerated in the counts of the 2023 case, and also for the witness who is enumerated in the count of the 2024 case. He's to stay away from those witnesses. He's also to stay 100 yards away from D&E Pizza. And he, I think that what Judge Pomerol has ruled upon about his coming into the courthouse, he comes into the courthouse as a journalist.
Good, thank you.
Going to suggest that when he comes into this courthouse, that he behaves according to the sentiments that have been expressed here. And my order to him is that he's to behave in an appropriate manner and not to in any way try to intimidate or harass any witness. And that would also extend to 300 feet around the courthouse so that he can get in and out of the courthouse. during the Reed trial.
He can
So
go to
that's
the
my
Reed
order
trial.
on the case.
Judge, may I ask, in terms of the stay away order, and I think this is typical, are you accepting the defense team, investigators, et cetera, if we need to talk to witnesses?
Absolutely. The defense team can reach out to witnesses if they want. That's what defense attorneys have to do to defend their clients. So you can have an investigator or yourself, Mr. Bradl, or learned counsel, Mr. Bederow, as well.
Thank you.
But
Learned?
I don't
Did you say
want
learned counsel Bederow?
anybody else to be reaching out to witnesses.
I understand, Your Honor.
I also have a question.
Go right ahead, Mr. Cosgrove.
I don't mean to press Your Honor too
Yeah.
hard on this. But I noticed as you announced your decision, you indicated
No bail.
100-yard stay-away zone
From the B&E pizza,
from
D&E
pizza, which
Yeah.
I appreciate. I think it would be very advisable to extend the same order with respect to the homes of the witnesses in these cases,
Okay.
given the history.
Let me talk to Mr. Bradl about that.
Can I have one moment, Your Honor?
Yeah, why don't you talk to your client?
Learned Mr. Bederow has entered the chat. Who's changing their name first to Learned Mr. Bederow?
Judge, we'll agree to that under section
Okay.
87, yes.
That's fine.
Thank you.
Okay, so it would be the same thing, 100 yards away from the homes of the witnesses in the case. Why don't you give me a next date that works for all counsel on the case? We still have the matter from yesterday under advisement.
Yeah,
Judge,
that's
we
the
have,
motion to dismiss.
just reminding everyone that you mentioned that 10 days, we want to address or file pleadings relative to the journalist
Yeah,
issue and the taint team. Should we pick a date, maybe 20 days out, 30 days
I'd
out?
say probably sometime at the end of April.
End of April.
What, April 23rd?
I'm not a good week, Madam Clerk. Can we go the next week?
That's fine.
April 1st, or, I'm sorry,
No.
April 30th.
That works for us.
All right.
Unfortunately, I've neglected to bring my calendar with me, so why don't we say April 30th? And if there's a problem, I'll consult with Mr. Bradl and get back to
That's
the
fine.
court.
Okay.
That'll be
Thank you.
Okay. Thank you.
Thank you, Your Honor.
Attorney, your conditions of release are amended as you are ordered to stay away, have no contact, direct or indirect, from all the witnesses in your 2023 and your 2024 cases. You're also ordered to stay 100 yards from D&A Pizza and the residences of all the victims, the witnesses in these cases.
Victim.
And you are ordered to behave in an appropriate manner while in the courthouse and 300 yards of the curtilage. You assent to those conditions?
300 feet.
And you're hereby notified if you're charged with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58, and your matter is continued to April 30th at 2 p.m. For hearing on any motions. Thank you.
Okay, thank you all.
Your Honor, I think we're all appreciative that you were able.
Well, that attorney Cosgrove, he's the special prosecutor here because the special prosecutor had been Ken Mello, but we don't know where he is. We were asking for proof of life for a long time, and it turns out that he may be sick because they said he was not going to be able to come in court and testify because Turtleboy's team wanted to call him as a witness in the case in which perhaps Ken Mello and Tully and Kate Peter and Lindsay Gattani were all texting each other to try and set him up to put him in jail, which is the defense theory of what happened here. So new charges, witness intimidation charges against apparently Chris Albert and Colin Albert for looking in the window of D&E Pizza and saying some things. If you're tuning in late, then you missed me reading the actual charges or the statement of facts, and we only have the first page of it because that is the only thing that was made public. But apparently he looked in the window, stared at the camera for 25 seconds, and then said some things into the camera. Hi, Chris, what have you done? Murdered, misses you. I read all of that before. So did special prosecutor Cosgrove, because the Norfolk County District Attorney's Office just has to hire out for everything because nobody wants to cover this. Who is this? Is this Judge Doolin? Stick around because we're going to go over the hearing from yesterday on the motion to dismiss. We now have video of it because Turtleboy put it up. I'm sure that he's going to allow me to play it and talk about it because he plays my stuff all the time. So we're good on that. Is that Judge Doolin? Doolin? Really, really like him a lot. I like him a lot. So he's got to stay away from all of the witnesses in his case. They did not say all of the witnesses in the Karen Reed case, interestingly enough. The judge looked like he had really had enough of it. And he's like, what the duck are we doing here? And he did make a distinction between the other cases, because in this particular case, Aidan Kearney was not creating content. He was not the one filming. It was Chris Albert's camera filming from inside or outside of D&E Pizza. And so he has to have no contact with any of the witnesses in his 23 or 24 case. And he's got to stay 100 yards away from D&E Pizza and also stay away from 100 yards away from any of the witnesses' homes. But he does get a 300-foot curtilage to get in and out of the courthouse for the Karen Reed trial. That is what the judge specifically said. And what he did not say is that I'm imposing bail. And that's what Cosgrove wanted. So this is crazy. It's insane. We're in Norfolk County. It is the land of the upside down. It's the Matrix. We're in the Chronicles of Narnia. And now it's almost like the apocalypse. We're in the apocalypse. Fire on acid. Thoughts on the Sally Port pop-up edit. Do you think they will bring this up to Judge Cannoni? How can she ignore that? I don't know. I don't know. They may. I don't know if that's a pop-up that comes up because you have a certain program installed. I don't know if that's a pop-up that comes up because you have used that AI editor before, but we just thought it was crazy, and that's why I paused on it. So I really don't know enough about it to even say what it even really means. Thank you so much, Drea, for your super chat. I appreciate you so much. Also, shout out to Alicia Joe. I don't know if you're here watching today, but you did leave a comment that I didn't address your super chat yesterday. I thought I put every single one of them on the screen at some point. I've not had a chance to go through all 6 hours of footage yesterday, but you did send a nice comment with a super chat, and it was a compliment to me. And so thank you very much. I appreciate you so very much. Mama She, thank you for the 10. I love both pieces. The sweatshirt, I went to Cancun with Melanie Little. Oh, you like that? It's so super soft, and I have to live in it. Oh, thank you. I'm glad you like it. We've got merch. I think it's probably pinned below. I went to Cancun with Melanie Little, and also the free Karen Reed shirt that says stay cool, stay kind, stay classy on the back. Greg, thanks for your 10. At the risk of being crucified by chat, when I heard the details of the new charge, all I could think to myself was, come on, Aidan, I'm on his side here, but he doesn't make it easy for me sometimes. I know. I hear you, Greg. I hear you. I'm sure his lawyers were not happy. But again, is it protected speech under the First Amendment? That's the question. But again, I don't know. I can't. Nellie, Grace, thank you so much for your 10. I was outside court yesterday. I believe they took one look outside at the line waiting to get in and switched Aidan's courtroom to a smaller one. Then they muted the Zoom. Thank you for being boots on the ground. Susan, unless Chris hasn't noticed that there's audio recording in process, this is wiretapping according to Massachusetts law. It's a felony. I don't know anything about that. I do not know. Isn't it illegal to record video with sound? Thought that was wiretapping. I don't know enough about the wiretapping laws in Massachusetts to even give you an opinion on that, both of you, but thank you for asking. I'm sure somebody can do the research on that. And I don't know if he's got signs outside saying, you're being recorded. It's not really the issue here today. Colin did it, has changed his or her name already, and says, your chat inspired me to join the club and get creative with my handle. Love it here. Well, we love having you here. And your new name, Colin did it. You're first up with that name. Congratulations. And Emma's here from Ireland. Someone must have been watching Aidan and company in McCarthy's for Chris Albert to know to check his video. I'm sure he checks his video every single night. But yes, I'm sure he's being followed around. I think they were posting pictures while they were at CF McCarthy's, because we know from the pictures that he was with Meredith and Will the Glare and attorney Nan Gallagher. So we know that's who was with him from the photos on social. Dr. Hired One, if a tree falls, can you hear it? If the audio is hard to hear, did the person actually hear what he said? Great point. Is there metadata? Greg, I haven't seen a judge with that look on their face since Judge, I don't know how to pronounce that, when TMZ showed up. Uncivil, do you know what time your stream is ending today? I don't know. I think maybe after we watch this motion to dismiss. I don't know how much more I have after that. So that's probably like a half an hour. And that is very nice for you to reschedule your stream to follow mine if that is in fact what you did do, unless you're actually live now. Andrew, thank you. It says they think Mr. Cosgrove has a colonoscopy coming up. Maybe. That's why he keeps saying colon. Maybe he's thinking about the prep and he's just like, he hates it, like everyone does. Aileen Champagne, how about a shirt with a picture of a real colon on it with the words "did it" underneath? LOL. Somebody else can do that one. I don't think it's on brand for me, but somebody else can do it. Good idea. Edward, this is not criminal felony speech. There are no fighting words. This is a civil matter at best. Sue Aidan for defamation and libel. Well, that's what he said. It's a tort. He even said Cosgrove admitted it was a tort. It's a tort, but you know, they'd have to hire lawyers. It would be really expensive. But it's defamation per se because they're accusing someone of murder. Yeah, but that's a civil cause of action. Mike B from the 413. This is looking like Cosgrove got home yesterday and realized he didn't do so well and he wants to redo it. Well, at the very beginning of the stream, we watched what happened yesterday. He kind of wanted to address it yesterday, but the judge gave Bradl and Bederow and Aidan the night anyway. Rafferty's statement doesn't say FBI is closed, says Amelia. I'm not sure. I thought she said that it is going to be over, something like that. Potentially criminal. The state accuses people of all kinds of crimes. They do. You're right. Who is this anonymous witness? Seems important. I know Edward was one of the people that was with him. I turned over a lot less. We were duped. Says, I think the judge is asking under his breath, what in the heck is wrong with all of this? Yeah, I think we all are. Karen, why haven't they Sundayed him yet? Sundayed him? And how did Tully, who set Aidan Kearney up and put him in jail, get to be the one to bring these charges? Well, because Chris Albert emailed him the video. So if you weren't here at the beginning, go back and we read the first page anyway of the statement of facts. And that's how the charges came to be. Chris Albert sent Tully the videos by email. I don't know. We don't know if they spoke on the phone first, but that's how it happened. BC, thanks for your super sticker. K-Max says, why, Colin, why? Thank you. Victor Man, what attorney comes to court without a calendar? You know what I think? I think that he doesn't know how to use the one on his phone. And he has like a day planner or like the big red book. If you're a New York lawyer, you know what that big red book is. It's like a diary that comes every year and it's like giant and like 7 inches thick. I think that's probably why, because the red book was too heavy. Michelle, I'm late to the potty. Do the other potties have stay away orders from Turtleboy? Do they? Does anybody have a current stay away order? I don't know. As far as I know, most of them were denied. Or are the conditions of his bail on the other cases that he's got to stay away from all of these people, like their physical bodies? Somebody in the chat can probably answer that better than I can. And Suze, if you're in there, maybe you can shout out to Michelle and let her know. Commonwealth of Massachusetts says, remember, there were male witches persecuted in Massachusetts too. I guess they're still continuing to. Thank you. Chloe's in scissors. Was this judge on Morrissey's list of emails? No, all of those judges were Stoughton judges. But who knows? Because Morrissey's emails have since become discoverable. And so we don't know who else he was emailing. So that's a good question. Ken Mello was my dad's attorney. He's really ill. Oh, I'm sorry, Danielle. Sorry to hear that. They did say that in court. So USMC Cowgirl, you're killing me, Smalls. You're killing me. Aidan should have said he was talking to his reflection. Well, there's two Aidans, he said, right? Cosgrove said there's two Aidans, the one that comes to court and the one that you see outside of court. Which Aidan was it? He could have been talking to his other Aidan. He could have seen his other Aidan in the reflection of the window and was talking to his other Aidan. That's right. Great point. Positive vibes. I'll allow it. Edward, can we talk about that? It seems to be standard practice for Massachusetts prosecutors to testify, have not sworn affidavits or for anything they argue. Yeah, they just get up and they just make, statements of fact. And we should just believe it because they said so. It's called Ipsy Dixit. It's our new favorite Latin phrase. And Protocaster says that AI suggestion pops up on that Windows installed media viewer. Mine did it this morning when I opened a picture. Interesting. So what if you do use it? Will it stop popping up? Does the fact that it popped up indicate that it has never been used before, that it has been used before? I have questions that I can't answer because I'm not, not a techie. All right. This is yesterday's hearing on the motion to dismiss. We're going to talk about it. We're going to watch it. We're going to dissect it as we do. And so we had to miss it yesterday because they muted the Zoom, but now the video's out. So let's take a listen. God save the Commonwealth.
Numbers 10 and 11, Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43.
God bless this court clerk because she knows how to pronounce Kearney. Props, sis.
Let me just update this. Mr. Kearney is present and represented by attorneys Timothy Bradl and Mark Bederow. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on the defendant's motions to dismiss. If the parties could please identify themselves for the record.
Morning, Your Honor. Robert Cosgrove for the Commonwealth. And I guess it's a late morning. I should have said good afternoon.
Hello, Your Honor. Timothy Bradl on behalf of Aidan Kearney. He's here in my, to my left. And Mark Bederow, Mr. Kearney.
Mr. Bederow. Good afternoon. Okay. So I got the motion and I got the response. Why don't I do this? I've got some questions that I'll throw out at the beginning, and maybe both sides can answer them. Why don't I start with the defense and then I'll go to Mr. Cosgrove. So Mr. Kearney certainly a journalist. He's a satirist. Mr. Bradl, where's the line? How far can he go to satirize things? And when
He's asking about satire. I think he said clearly Aidan Kearney is a satirist. How far can you go with satire? I want to hear it again because I can't get closed captions on this. They don't exist.
a journalist, he's a satirist.
He's a satirist. He's calling him a satirist.
Mr. Bradl, where's the line? How far can he go to satirize things? And when does it become a crime? I asked that to Mr. Cosgrove as well to address. How does the conspiracy counts, which are 14, 15, and 16, how do they fit into this? How is that intimidation? Are there people that are mentioned in these indictments who are non-witnesses, specifically as to counts 5 and 15? Tell me, Mr. Bradl, where you think that the motorcade, how does that fit into this? Where does the intimidation there, Mr. Cosgrove? You can obviously speak to that, but Mr. Bradl, I'll start with you.
Thank you, Your Honor. You know, as usual, Judge, you cut right to the point. I appreciate that. You know, we have about 75 pages between counsel and I, and I'm happy to answer those questions. The first, where do you draw the line thing, Judge?
Yeah, where do you draw the line?
Sure.
So he's a journalist. He's got his blog. He's got the website. I'm sure.
And he's calling him a journalist. Praise be. He gets it. Somebody tell me if this is Judge Doolin. Anybody know?
Sure, he gets a lot of activity, and he's covering a case. So he's acting as a journalist. But how far can he go?
Sure.
You know, and I say this to Mr. Cosgrove maybe as well. How about Michael Moore or somebody like that, or somebody who's a satirist in some way? I was trying to bring it to.
Michael Moore has entered the chat. Thank you, Microdots. Hey, Richie. What a difference a fair judge makes. 100%. Thank you for your super chat. Michael Moore has entered the chat. This is Judge Doolin, Doolin, and we love him. I do anyway, so far. I'll allow it.
Attention to a certain thing. How far does the First Amendment go in their protections?
Sure.
Go ahead, Mr. Bradl.
Thank you very much, Your Honor. Judge, it is actually a clear line. It's O'Brien v. Borowski. Okay, Judge, I know you're all over this. O'Brien says that all of these strictures that talk about speech and distress and everything else, it's limited to true threats and fighting words. O'Brien says that. Watts in the Supreme Court says that. This is just well-settled law. It's unquestionable. So it has to be true threats or fighting words when the issue is speech. And that's what we have here, we contend, is this is just Mr. Kearney's speech.
How about if he says words to the effect of a ruin in the leg? Is that enough?
No, it's not enough
Okay.
because it's not a specific threat in terms of any criminal behavior. And that actually is specifically addressed in O'Brien, and it's Snyder v. Phelps, Judge, Snyder v. Phelps. That's the Westboro Baptist Church case where they picketed a dead soldier's funeral. I mean, the most repugnant stuff you can imagine, but it's inflicting emotional distress in public on a matter of public concern is protected. So, and O'Brien specifically talks about that the fear needs to be defined. It's fear of property damage or being a victim of a crime. It's not fear of being sued. It's not fear of being embarrassed. It's not Ms. McCabe in Stoughton District Court saying, is there any way you can get him to stop blogging about me, Judge Walsh? That's not the fear we're talking about.
How about calling it phony pizza
That was denied.
rod instead of pizza restaurant?
You know, I'm glad you brought that up too. There's no evidence whatsoever, and he did do that. Mr. Kearney did not tell people to do anything with respect to that, but more to the point of our
What did he like? Not to go to the pizzeria? Wait, I didn't hear what the judge said. Hold on. And then it's ironic that this pizzeria thing comes up at the end. Hold on.
fear we're talking about.
How about calling it phony pizza rod instead of
Oh, calling in phony pizza orders.
pizza restaurant?
You know, I'm glad you brought that up too. There's no evidence whatsoever, and he did do that. Mr. Kearney did not tell people to do anything with respect to that, but more to the point of our motion here today, there's no evidence of that. You know, I don't want to sound sneaky when when I say, oh, there's no evidence of that. He didn't do it, A, and B, there's no evidence of it, and that's what we're here for, is to look at the evidence in the grand jury. There's no evidence whatsoever that he told anybody to inflict economic harm on the guy. Even if he did, which he didn't, how is that a crime? It might be something he could be civilly sued for, but it's not a crime. But the most important point on that, Judge, is that he didn't do it, and there's no evidence of it. That points up something that we want to address as well, Your Honor, is the idea that there's so much imputed derivative liability infecting these grand jury minutes. It's ridiculous. You know, it's as if the Commonwealth just basically forgot about the notion of joint venture and just wanted to attribute every bad thing that has happened to any one of these complainants to Mr. Kearney. I'll give you a ton of examples. Proctor says people drove by and spit on my lawn or whatever. That's got nothing to do with Mr. Kearney. They have no evidence. He said, hey, let's get into joint venture here for you to drive by and spit on his lawn. It's got nothing to do with Mr. Kearney. Another example that should throw out the entire case is McCabe. Jennifer McCabe says, I got an email that someone was going to rape me on my front lawn.
Oh man, what?
That has nothing to do with Mr. Kearney. The fact that there are other people, many of whom are in this room supporting the First Amendment and supporting Mr. Kearney, that are concerned about this and that speak out, Mr. Kearney is not responsible if they cross some line. It's not his cross to bear, Your Honor. If the government wants to make a joint venture case, let them try, but they certainly haven't here. And that's the most important point, is that all of these derivative liability things, you got to throw those out the window, Your Honor. You can't use them as a basis to uphold an indictment, but also there's no evidence of it. There's no evidence that he did anything wrong. So all those derivative liability things, Judge, I hope that, I know you've looked at everything. When you look at it again, it can't apply to Mr. Kearney. It's just not within the law. It's not even, Zanetti, defense lawyers talk about Zanetti all the time, about how broad it's become. It doesn't even come in the galaxy of Zanetti. There's no evidence that Mr. Kearney urged anybody to call the pizza man and, order things and not show up. There's no evidence about the Proctor thing. He's got nothing to do with the Jennifer McCabe emails. All these things, Judge, are the government's attempt to just throw enough mud at him so that a judge who's swamped with these things, says, there's all these allegations. I know you're not going to do that, and that's why we're here in front of you, is because we have every bit of faith that you're going to look at this in the way that it needs to be looked at, and that you're going to look at it on the right side of the First Amendment, Your Honor. The derivative
I love how Bradl like compliments the judge so much. He's like, Judge, I know you're on top of this. Judge, I know you know the law. Judge, I know, it's a very smart tactic. And I think he really does believe it. Thanks to whoever wanted the link to the merch shop. It is pinned in the chat for those of you who want to check it out. I got to tell you up front, it's not Amazon. It's not going to get to you in 2 days. It may take a week to get there. So you may want to order soon if it's stuff that you want to wear if you're going to the courthouse at any point.
liability stuff's got to be out the window.
Okay.
Can you refresh my memory on your next question, Your Honor?
I think I had asked a couple of questions, one of which was, where is the line, the conspiracy, which I think you talked about,
Yes.
and then the motorcade, which you talked about as well. How about the one with people who, in counts 5 and 15, who are at least, it's the same person, but are, it's intimidation of a witness. Is that person a witness?
I just don't have it in front of me, Judge, in terms of 5 and 15 is the allegation. Elizabeth Proctor, yes, she's not a witness, but the breadth of the witness intimidation statute, Judge, does cover family members of a witness.
Okay.
So I'm not taking issue with that, but it just goes through every single one of these. It doesn't rise to the level of threats or fighting words, Your Honor.
Right.
It's just, and the other.
We went over the motion to dismiss in the papers. It's got to rise to the level of fighting words. Oh, look at my freeze game is on point right now. That's a great picture. Let me take this down in case we need to, screenshot it to show him. It's like he's praying to the justice gods. Love it.
Huge issue that the Commonwealth ignores and just wants to look the other way and go after somebody out of their own self-interest, and we'll get to that later. But is this notion that political hyperbole is somehow off the table. So I'm going to rewind a little bit, and that's the Watts case. Goes back to 1969, Your Honor, when a guy who was speaking about the draft, and he said that if they put a rifle in my hands, the first person I'm going to get in my sights is the president, LBJ, Lyndon Baines Johnson. And he was prosecuted under the federal threat statute. And the Supreme Court, they laid it out very clearly. This is called political hyperbole. The context, the distance, the First Amendment aspects of it, it's political hyperbole. It's not really going to happen.
Right. It's not fighting words. Just to clear this up, Scott, the judge's order was all witnesses in the Aidan Kearney matters, in the 2023 matter and the 2024 matter. I think 2024 is Lindsay Gattani. 2023 is a lot of witnesses that are in the Karen Reed case, but not every single one of them. So he did not order all the witnesses in the Karen Reed case. So I just want to clarify that. Somebody's wearing a Turtleboy shirt in the gallery. I did see that. I did see that. Yep.
It's something that a First Amendment protected speaker says to underline their point, to underscore the force, the rhetoric.
And also, let's just clarify that this is yesterday's hearing. So this is on the motion to dismiss. We've already done the hearing on the new charges. That was at the beginning of this stream. So those new charges didn't happen yet. And he's not talking about that right now. What he's talking about right now is the motion to dismiss for all the witness intimidation charges, which we went over in another stream. I have a playlist, and so you can go back and watch it. We went over the papers, saying that this is freedom of speech. This whole statute is violates the First Amendment because everything that he said is protected speech. He didn't say anything that rises to the level of fighting words. If you are confused about what we are watching, it is scrolling at the bottom of your screen. Okay, cool. Here we go.
Rhetorical force of what they're saying. So that principle, Your Honor, is sort of the foundation for a lot of the case law that we cite in the brief, and that, it's
So words to the effect of, I'm going to destroy someone's life, or I'm not going to I'm not gonna let them lead a comfortable life.
Right,
That's what your argument is, that
exactly.
even under that case law, which is obviously, a little
Control.
bit different, but yeah.
Controlling, Your Honor.
That's,
I think the word you're looking for.
well, that might be your word. I'm saying that,
You know, it's the Supreme Court, and that's another issue we want to talk about, judges. You know, the Commonwealth of Massachusetts just forges ahead with this ridiculous statute, this witness intimidation statute. If that statute was passed in 1775, every single one of those legislators would have been pulled out of the State House and tarred and feathered on Boston Common. That statute is ridiculous.
I love it. He's taken us back to 1775, and tarring and feathering has entered the chat. Oh, my freeze game is so on point today, right, you guys?
Your Honor. It talks about inflicting economic harm, inflicting emotional harm. I think someone's going to receive emotional harm if they hear speech that says, "You're a liar, I'm going to sue you." Under the statute, that's a felony in Massachusetts, not in the rest of the world, not in the rest of the country anyway, not under the Federal Bill of Rights and the First Amendment, but apparently in Massachusetts and in Norfolk County, it is.
Okay, let me turn to Mr. Cosgrove. I think you've answered that question.
Thank you.
Let me turn to Mr. Cosgrove. Mr. Cosgrove, maybe,
Lana is here. Lana is here. And if you don't follow her on Twitter, if you choose to wade in the cesspool of Twitter, which you know that I do not, you should follow her on Twitter because she's got some really, really, really good tweets, and she lays a lot of things out, as does Olivia Lambo. So you should follow both of them on Twitter if you choose to play there. I left the sandbox and I don't do it.
so some of these counts, I mean, there's obviously a lot of counts. There's
A lot of
16
counts.
of them. But going to count 8, which involved a member of the state police, where he's walking out of the courthouse here, and allegedly the defendant directs the attention of certain people towards him, and then they chant and they call him names. Does that rise to the level of intimidation of a witness?
I think that's probably the one closest to the line, Your Honor,
Okay.
candidly. But if you look at the testimony and if you view the video, you'll see that he's pursued down the street. He's shouted. He's approached by people accompanying Mr. Kearney with cards that they're waving and so forth. And I certainly think he could have legitimately.
Well, they're not really waving cards. I mean, they're signs. They're not cards. They're not waving around, a 3-card Monty like the prosecution is. But, they're signs. People have the right to peacefully protest and, stand up for truth and justice and the unreasonable and absolutely indecent persecution and re-persecution of an innocent woman, because John O'Keefe was not hit by a car. What is today? I told you what today was earlier. It is Thursday, March 6th, 2025, and John O'Keefe was still not hit by a car. And Microdots has this, I think, somewhere in his merch shop. Actually, it's showing up. I don't know if it's mirrored, but when I hold it in my hand, it's backwards. So it's framed and it's inverted, but I think when I hold it up to the camera, it might not be inverted. So Microdots also has merch. Do the hoodies run true to size? Sweetie, I don't know. I really don't even make any money off the merch because I don't even mark it up. I will tell you that the Bella and Canvas, anything that is Bella and Canvas, the brand is much softer and higher quality. I think that if there's a size chart in there, though, there should be for each item. Some are women's items, some are unisex. Hope that helps. Thank you, Green-Eyed Southern Girl.
Feared for his safety. The fact that he's he could have cards that they're waving and so forth. And I certainly think he could have legitimately feared for his safety. The fact that he's a rather robust gentleman and that there are other police officers around might mitigate that fear, but I don't think it was totally unfounded.
Okay. Well, but some of my other questions, just, as we get into these specific indictments, as to the indictments that are at the end of the 14, 15, and 16, to talk about the conspiracy with the person who evidently worked for the police department to get license
They brought
plates and
that up,
puts them out there. What's your theory on how that amounts to intimidation of the witness?
A conspiracy to intimidate a witness?
Yeah,
Which is a little different, as Your Honor knows, from the actual intimidation.
yeah.
There was testimony that this person had done this sort of thing for Mr. Kearney before, that she was familiar with his online activities, and that she knew that what was likely going to happen when she turned over this license plate was that it was going to be used to dox the witness. So I think that's the essential theory. And there was also a suggestion.
I don't think it was done to dox the witness. For those of you who don't know, I think they're talking about the woman who ran a plate for Aidan because Aidan wanted to know if it was Jennifer McCabe's car outside of Proctor's house, right? Help me, chatters. I'm conflating all of my cases. And so I don't think that he wanted to dox Jennifer McCabe, which means publishing her name, address, date of birth, social security number, etc. I think he just wanted to know if it was her car that was at Proctor's house, right? Because LA says it's a matter of public concern that Jen was at Proctor's house, is what I think you meant to say. Right? Okay. No, she was at Lang's house a different time. Let's not get, we're all conflating our cases. She was at Lang's house the day after. She was at Lang's house on January 30th, 2022. I don't remember exactly when she was at Proctor's house, but she claimed, can't even remember why she claimed that she went there. But again, so much of this stuff would not even be known if it wasn't for Aidan Kearney and his investigative reporting. And this judge at least has the respect to call him a journalist, which most other judges don't. They call him a blogger. He's a blogger, as if what he does is not important. He's done more investigative reporting on this case than any journalist out there. And he has in large part, the reason that there's worldwide attention on this case. I will say personally that when I started covering this case, I did not know about Aidan Kearney and his journalism. But for many people, that was their first entree into the debacle that is the wrongful persecution of Karen Reed.
As I recall it, that she herself had some interaction with Mr. Kearney in the past in connection with a niece or something like that, and didn't want to get on his bad side. And I would suggest there was a reason that she didn't want to get on his bad side.
Okay.
That's what she
As
said.
to some of the counts that go into
Right.
the motorcade, where it goes to different people's houses with a motorcade.
Oh, it's a motorcade. It was a rolling rally, but he's calling it a motorcade. He's calling it a motorcade. Reminds me of the JFK Zapruder film, the motorcade. I love it. Yes, Susie, that's what it was. Jen said that the reason she went to Proctor's house is because it was two harassed mothers coming together, because she says that Lizzie Proctor too was harassed, right? Farmer, that's a good one. Very funny. I'm an honest and truthful person, but Alessi says an honest and truthful person. That comment went by too fast. I couldn't.
Follow this. The actions of Mr. Kearney, are you suggesting he's acting as an individual, or he's acting in some sort of joint venture?
A joint venture.
Well, I think the evidence would certainly support joint venture. Essentially, there was evidence that Mr. Kearney planned this motorcade, that he broadcast what the location, the gathering point was going to be, that he showed up with a bullhorn to address the crowd, that he had his cameraman, or perhaps it was he himself with his phone to film the events for later broadcast, that these people proceeded at his direction to the various locations. Only the first location was announced in advance. So they got there by following him. And when he got there, he got out of the car, and statements varied somewhat from location to location, but harangued the occupants of the house as to...
So let me ask you about count two. So count 2 talks about intimidation of a witness, 25 to 30 people. Mr. Kearney with a bullhorn telling a witness to tell the truth. How is that not free speech?
Telling a witness to tell the truth. Now, listen, if you're going to argue, Mr. Cosgrove, that telling a witness to tell the truth is trying to get them to change their testimony, then you are essentially admitting that they are lying, right? Right? If he's saying tell the truth, and you're saying that that is he's trying to get them to change their testimony, right, under the statute, then you're admitting that the witnesses have been lying. So he's trying to get them to tell the truth, because if they've been telling the truth all along, then he's not trying to get them to change their testimony. Do you see what I'm saying? Did that make sense? Thank you, Emma. Thank you, glazed and confused. Been saying this since day one. Yes, yes. Does everybody understand now? The judge does. The judge understands. We love Judge Doolin. Judge Michael Doolin for president. Judge Michael Doolin for the Karen Reed case. He'd be like, I'm sorry, why are we here? I'm sorry, you did what with you never turned over all that video that you've had since the day of? And why is a Canton police detective downloading this stuff when nobody in Canton was supposed to touch a ducking thing? Right? Right. Water boat. We got the Chinese water torture today. We got the motorcade. We've got people holding up cards. I mean, there's so much comedy gold here that we're going to have to recap the comedy gold. We've got orphan methodology in here, but that was, truth be told, that was not from a Kearney hearing, but well done, my girl. Well done.
Well, the one that involves name.
It's the one that involves what?
Ms. Name, I'm sure.
Oh, the one that involves Ms. Nagel, tell the truth. Okay, so in order to argue this, Cosgrove, you're going to have to say that you believe that Julie Nagel was lying. I'll move myself so you can see Aidan and Bederow. So this is regarding Julie Nagel. Tell the truth.
Well, I don't want to sound like Bill Clinton. It depends on what the meaning of is.
All right.
But
Bill Clinton has entered the chat now. And I told you guys the other day that I watched Monica Lewinsky on Call Her Daddy, and I put a comment in there. So if you could please go watch that. It's fascinating. And let's try and encourage Monica to come on my show. She also has a YouTube channel. I would love to have Monica on my show. So Bill Clinton has entered the chat now too.
I mean,
in the context of Mr. Kearney saying, tell the truth,
Kearney.
I think the witness would clearly understand that what he's instructing the witness is tell my version of the truth.
okay.
Mind meld.
In other words, don't change your testimony or don't testify.
No, because that's not what he's saying. He's saying tell the truth.
And then
He's saying tell the truth. He's saying tell the truth. He's not saying if you testify, I'm going to have you killed. Like maybe Whitey Bulger might have said, because, snitches get ditches or stitches, depending on where you are. He's not saying to change your testimony. He's saying just tell the truth. See what he said. Let's hear that fakakta argument again.
In other words, don't change your testimony or don't testify.
No.
okay.
Look at Bederow.
And then, how about releasing the phone numbers to the public? In your view, does that cross the line, taking the phone number of an officer or of a private citizen and putting that out on his website? Is that something that you think is protected speech? Obviously, Mr. Bradl does, but from your point of view, does that amount to intimidation of a witness?
I think there's a distinction between your ordinary, if there is such an ordinary thing as putting somebody's phone number on a website and doing it to a witness in a criminal case with the intent to intimidate that witness. And I think this also relates to a comment that Mr. Bradl made from the defense perspective. the court is to look at this with a very limited lens. Just look at what Mr. Kearney did. Don't look at what else happened. The fact that Mr. Kearney said throw a rock or show up for an exhibit or.
Oh, I want to just point out what Bederow is doing with his hands. Okay, this is called steepling. This is called steepling. Look at your video for a second. This is what powerful people do when they're trying to convince people in a group setting or in a sales meeting. They steeple their hands. Well done, Big Bad Bederow. Say.
Lens, just look at what Mr. Kearney did. Don't look at what else happened. The fact that Mr. Kearney said throw a rock or show up for an exhibit or, and that's a hypothetical, or show up for an event, or here's the phone number, go ahead and call. Well, he's not responsible if what results from that are a ton of annoying phone calls, obscene phone calls, etc. But I would suggest that that's the intent, clearly, that the grand jury could find in posting that, and that's the practical result of what's being posted. And the intent further is to harass and intimidate the witness.
Okay. Anything that you want to say that you haven't said already, Mr. Cosgrove, in support of your position? I know I started off by asking questions, but if you have anything that you want to direct my attention to,
Sure.
what you think is important, I'm happy to listen, and I'd offer Mr. Bradl the same opportunity. I've read everything that both of you have submitted. Well, let me start with Mr. Cosgrove, and I'll give you Mr. Kearney.
I'd just say a couple of things. First, I heard Mr. Bradl say there was no evidence of this and there was no evidence of that. And with due respect to my brother, I think he's making a layman's mistake in his characterization of evidence.
Do not call your brother, who is an officer of the court and a fellow attorney, a layman. Making a layman's mistake. Oh, you know what those are? Those are fighting words. Those are fighting words, Cosgrove. Did you just accuse your brother Tim Bradl of making a layman's mistake? Oh no, we got to hear that again. Hold on.
And with due respect to my brother, I think he's making a layman's mistake in his characterization of evidence. When a witness testifies that I was watching a YouTube presentation and I heard Mr. Kearney urge people to order pizzas and not pay for them, that's evidence.
A YouTube presentation.
Grand jurors can believe it or disbelieve it. The defendant can contest it in court if that same evidence is offered in court. But the fact is, it's evidence of what happened. So I don't think the statement that there is no evidence is accurate. I think in a broader sense, Your Honor, the difference between Mr. Bradl's position on behalf of Mr. Kearney in the Commonwealth is that when you ask, where is the line?
Yeah.
Mr. Bradl's position is essentially there's no line. The Commonwealth's position is that whatever might be the case, there's two lines of cases. There's the line that Mr. Bradl is relying on here. And he suggests that to be consistent with those cases, which talk about imminent harm and which talk about threats being made to the person's face and threats of bodily injury and so forth, that this statute must be unconstitutional and that it is to be construed consistent with these civil cases that he cites. And both of the cases that he mentioned are civil cases. The Commonwealth's position is that whatever the position.
Anytime, and I agree with this M99 says, well, he did say with all due respect, anytime somebody prefaces something with all due respect, they are about to disrespect you. That is just like, with all due respect, I think you're a complete a-hole. I mean, that is always followed by something that is meant to disrespect you.
Towards the general public, and alluded to that earlier. The courts have said that restrictions are possible when there are reasonable limitations as to time, place, and means. And we see that in a number of ways in cases that have been approved by the courts. Cases that have recently had an approval of Judge Cannoni's order with respect to picketing in the Karen Reed case. That wasn't held as an unconstitutional violation. We have decisions in 209A orders where judges order, and I'd cite the court to the case that I didn't mention in my brief, Commonwealth versus Butler. What happened in that case, I think it's fairly well known. Your Honor may be familiar with it. Young woman on the day of her birthday went to her door and found some flowers that were anonymously delivered. I think we'd agree that if you send somebody some flowers on her birthday, that communicates typically a message. Hopefully the message it communicates is happy birthday. Unfortunately for Mr. Butler, about 3 months earlier, the court had entered a 209A order, no contact directly or indirectly. They traced the flowers back to Mr. Butler, was prosecuted, found guilty, the conviction was upheld. That sort of thing happens on 209A orders all the time, which ostensibly you could look at on their face and say, oh, this infringes on my right of association. This infringes on my right to travel. This infringes on my right to make witty satirical statements. Nevertheless.
But Mr. Kearney is a satirist. I mean, in essence, a lot of this is satire.
Well, I don't mean to be flip, but
Mr. Cosgrove, he's a satirist. He's a satirist. Somebody asked, what is a satirist? It is somebody who engages in satire. Like, name some people who engage in satire. Larry David, I think, is quite the satirist. They brought up Michael Moore earlier. And so even the judge is like, yeah, but he's a satirist. He doesn't really mean what he says. Somebody says the judge is a turtle. I don't know. Yeah, Massachusetts is a crazy state. With all due respect, I think you're Andy Kaufman, another good one. Saturday Night Live skits or satire. Excellent, excellent examples. Howard Stern. Well done. Well done, chat. You are the snark tank for a reason.
But so what?
Okay. No, I mean, that's fine.
I don't think there's a special rule for satirists if the so-called satire is made with intent to intimidate.
Witness. Okay, that makes sense. Yeah.
He's open to other perspectives. That makes sense. Susan's pointing out the 209As are restraining orders for domestic violence. Family members, they are drastically different. And you are absolutely right. We learned about 209A orders in the murder of Katie McLean, for which Dr. Ingolf or Harry Turk, his trial is going to start. Jury selection starts in Turk in the same building in Norfolk Superior on March 25th. And it's interesting because I got a scheduling order yesterday from my amazing paralegal. And it says that the Turk trial is going to be in the small courtroom. I don't remember exactly what it says right now, but it made me believe that they think the Turk trial is going to be done before the Karen Reed trial starts, because the Karen Reed jury selection starts April 1st. And then the jury selection may go on for a while. I think they're anticipating that the Turk trial is going to be finished by then. And so I want to cover the Turk trial. Please go back and watch my coverage on that, because we have some things to catch up on as we do Brian. There's a hearing on Brian Walsh tomorrow, which I think we should cover as well. So let me know your thoughts.
I see your argument.
I'll stop at this point.
That's fine. I'll give this to Brad. I'll give you just a minute. You've made your argument pretty well, but anything else you want to say?
There are some things, Your Honor. I just invite your attention to pages 9 and 10 of my brief, Judge, where the standard of how this speech is supposed to be judged is set forth. And just a couple of quotes. Speech on matters of public concern is at the heart of the First Amendment's protection. Speech concerning public affairs is more than self-expression. It is the essence of self-government. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. The Commonwealth is arguing the other way around. Give us the benefit of the doubt, Judge Doolin. Hey, evidence can be construed in different ways. Evidence needs to be linked to a particular person committing a crime. That's what they're lacking here, Judge. And this Janelle Webb conspiracy to run a license plate business, Your Honor, the Commonwealth indicted Ms. Webb and then for some reason, and I think I know the reason, thought better of bringing the case to court and never arraigned her, never charged her, never did.
This is important. This is Ms. Webb, the one who ran that plate for him. So listen to his argument. I'm going to take it back a second. The Turk trial jury selection is starting March 25th. They moved for a change of venue, and Kevin Reddington, who is representing Harry Turk, who allegedly, well, he actually confessed to strangling his wife and throwing her body in a pond in Dover. That's out of Dover, but it's in Norfolk Superior Court. A lot of people didn't know Dover was in Norfolk County, but apparently it is. Kevin Reddington, who you may recognize by also being the attorney for Jennifer McCabe, got up in court one day and said during the hearing, which we still need to go over, we haven't yet, he was moving for a change of venue because he wanted to move to the county where Dr. Turk was a renowned robotic surgeon. He said, there are some there's some people covering this case, and there's one YouTuber who has credibility, and her name is Melanie Little. And then they put my name on the Chiron, and it says on Court TV, at the bottom of the screen, Melanie Little has credibility or something like that. It's hilarious. I don't know how Jennifer McCabe feels about that. Probably not great, but hey, I'll take it. Hilarious. Listen to what he says about Ms. Webb not being indicted or charged with running that plate.
The Commonwealth indicted Ms. Webb and then for some reason, and I think I know the reason, thought better of bringing the case to court and never arraigned her, never charged her, never did anything with that indictment, which I've never seen in my time. And I think what happened there was that the government, the state police probably realized that, hey, they run these plates on the sly all the time.
Right.
For boyfriends, girlfriends,
yep,
et cetera, et cetera. And they don't want in the system a precedent where a police affiliated person, quote unquote, runs a plate and then gets indicted for a felony.
That's right.
I think that's why that never saw the light of day.
Mm-hmm.
So
there
never was any conspiracy charge lodged against Ms. Webb. It's past the year presumptive speedy trial. So that case is effectively dead, Your Honor. That's an important fact the court ought to know.
The Webb case
also,
is dead.
It's not a crime to run a plate. So there was no criminal object of the conspiracy to run a plate. They just want to change, they want to erase the word conspiracy to run a plate, and let's put something in there, even though there's no evidence of it, let's put something in there that'll fly, like conspiracy to commit witness intimidation. There's no evidence whatsoever that 13B was implicated in any running of a plate. In fact, it's quite the opposite. It couldn't be more newsworthy. The district attorney had just gone on television with a remarkable statement vouching for witnesses in his case, that they were fine, they were on the up and up, and leave them alone.
That, but in terms of, so you're under indictments 14, 15, and 16. Your argument is that there's insufficient evidence for those to actually be a crime.
There's no criminal object. And even in the grand jury, Sergeant Tully admits, and he says it's not a crime, it's an administrative violation. He says words to that effect. You'll see it. And he does refer to that, and it's not a crime. That's why they couldn't say conspiracy to run a plate, against the rules, because it's not a crime. That's why they switched it to conspiracy to intimidate a witness. It's not intimidating to prove the exact opposite of what the district attorney said publicly, that these witnesses are affiliating with the state police and do know the state police and are visiting them at their home. So it couldn't be more newsworthy, Your Honor.
Right.
And that's what was behind running.
Right. Jennifer McCabe was visiting Proctor at his home. Mm-hmm. Was she dropping off the gift? We don't know. She was just visiting another harassed mom. They were commiserating about how they are both being harassed. Listen to that again.
Witnesses are affiliating with the state police and do know the state police and are visiting them at their home. So it couldn't be more newsworthy, Your Honor. And that's what was behind running the plate, was not to intimidate anybody, but to shine the light of day on corruption.
Okay.
So that's that. And Judge, another thing about, this First Amendment issue, and, whether it's a jury question or a judge question, this is a judge question. You're not the first trial judge that, even in my practice, that has dealt with this. And I put this in my materials. You have Judge Walsh and Stoughton.
Yeah, there was Judge, there were two judges, right?
Right, and so this Judge Walsh actually did two things, Your Honor. He did Mr. Schiffer, who's here in the courtroom today, and I appreciate it. My other client, Mr. Schiffer, is the guy that put rubber ducks all around Canton with political statements about the Reed case. And
he's in the courtroom. Rich Schiffer has entered the chat talking about the ducks. I'm going to take that back. Listen, if your mind has been wandering, come back. I beg your attention. Here we go.
With political statements about the Reed case. And remarkably, the Canton police is the guy that put Mr. Schiffer, who's here in the courtroom today, and I appreciate it. My other client, Mr. Schiffer, is the guy that put rubber ducks all around Canton with political statements about the Reed case. And remarkably, the Canton Police Department did a 37-page investigation that was, if they applied that much work to the Reed case, those folks wouldn't even be here anymore either. But they did a 37.
Preach. If they did that much work to the Reed case, those folks wouldn't be here either. Wow. Well done, Mr. Bradl. Well done. Somebody clip that.
7-page investigation into Mr. Schiffer putting rubber ducks all around Canton. And that's the Judge Walsh opinion, and you'll see it in there. Denied on First Amendment grounds. It's not witness intimidation. Denied on, and arguably.
But there's a difference between that and saying we're going to make the life miserable, isn't there?
Well, Judge, that's O'Brien v. Borowski. That's foreclosed by O'Brien. Fear of being sued, fear of being yelled at, fear of being embarrassed doesn't cut it. If I just could have one moment.
Yeah, no, take your time.
Oh, thank you, Bits and Blinkers.
So Judge, with respect to these rubber ducks, it's the exact same kind of thing that Mr. Kearney is accused of doing, and it's thrown out on First Amendment grounds. It's Colin did it. It's, statements about the case. It's the same kind of thing. And, they went after him. And that's what happens when these kinds of bad statutes get used for ulterior motives by self-interested police and prosecutors.
Thank you so much. It's been a wonderful argument on both parts.
Thank you.
Both briefs were very good as well.
Thank you.
I'll take it under advisement, and I'll have something for you soon.
Thank you.
All right. Thank you.
Your Honor.
Colin did it, actually.
Oh, yeah.
Oh, wait, and then we watched this at the beginning of the stream. So if you were not here for the beginning of the stream, go back and watch it, because that's when they had brought up the charges that he was charged with today, because we covered that hearing first. First, we watched that portion of yesterday's hearing. Then we watched today's hearing. We looked at the statement of the facts as proposed. And I just want to show you this screenshot here, because, this was my moment of fame. I was on an airplane when this, somebody told me about this. So I watched it on the airplane and made a screenshot, which says, there's Kevin Reddington in a court in Norfolk County. And it says, defense, there is one person who has some credibility in talking about the case, Melanie Little. And how much did it hurt Court TV to type that chyron out and put it on the screen? In the Massachusetts versus Turk case. Well done to me. I don't know. Is it better than a silver play button from YouTube? Probably not. But I thought it was pretty cool. So there's that. I agree with you. I think Aidan should be very careful of anything he says and does until this trial is over. I agree. It seems like Judge Doolin is going to rule on this relatively quickly, because he did say, I'm taking this under advisement, but I think that he wants to make a written, nice, thick written decision, and he wants to maybe make some law. I think he's going to toss it. That's my opinion. I think he's going to find that everything that Aidan did is under free speech, and that is why I would implore Aidan, even though I do not have any personal relationship with him at all, I would implore him to please just take a step back, Just let this settle. Let the judge come to his decision because it seems like it's going to be quick. Seems like it's going to be quick. Awesome. Awesome. Click and droppings. Well done. Click and droppings. Ordered a shirt. I'll show you the merch in case you don't know the lore behind it. So about last month, when did I go to Cancun? In January. I went to Cancun for Dave Matthews for 3 nights on the beach. I live streamed from it. A lot of you who like Dave Matthews watched it with me, and we got to watch part of the concert together. It was awesome. But he does it every year. And so last year was in February. And last year I was there in February. And after I came back, Alan Jackson was doing a hearing and he was wearing this cool bracelet. It was like a rope bracelet. And I said, oh, wow, that bracelet is so cool. It looks like something that I got in Cancun. I wonder if he was at Dave Matthews in Cancun. Well, the game of telephone started and the Twidiots were out there and that morphed into Melanie Little was in Cancun with Alan Jackson. So when Grant Smith Ellis was at court one day with his phone, he was chasing after Alan Jackson. And all right, he's got the opportunity to ask a question of one of the greatest trial lawyers of our time. And his question was, did you have fun in Cancun with Melanie Little? And then he shoved his mic in his face. And then he chased him up the courthouse steps and he did it again. So I thought, we're all in on the joke together. We're all in on the same joke. You too can get merch that says, I went to Cancun with attorney Melanie Little. That's the sticker. It also comes in other products like t-shirts, like, and this might be Bella and Canvas. I'm not sure if that one is, but this is Bella and Canvas, and this is a nice sweatshirt. And this comes in this color and this color. It comes in black and it comes in like navy, and then it comes in a mug. And it comes in some other kinds of shirts that you can see here. These are available in multiple colors. I bought this one. I'm waiting for it to get here, like what the duck. So I made the emblem a little bit smaller on the upper chest instead. And so I thought it was funny. And then what other colors does that come in? And that comes in like this oatmeal color. Let's see. And it comes in black and it comes in navy. Okay. There's that. Oh, and this is a cool hoodie too. I like this hoodie. This is an oversized hoodie. And then the free Karen Read stuff has let's see. Let's go back to the beginning here. This is the new free Karen Read stuff. So it's got free Karen Read on the front. And then on the back, it's got the stay cool, stay kind, stay classy. We are outraged with attorney Melanie Little on it. That's the front. And that's the back. And that also comes in, so that's what is that? That's the Bella and Canvas women's long sleeve t-shirt. So yeah, they do have a size chart here, so you can click on that if you're uncertain about your sizing. Somebody asked for a travel mug. So they don't have like a tumbler, they have this. So I put it up. I don't know how well it's going to print on this actually. So I really can't say that I recommend it because and also we have this pink. This one also comes in yellow. That's a men's hoodie. And then there's this pink for the women's hoodie. So that's the front, that's the back. Then there's fuchsia. No, this is purple. It comes in fuchsia. It comes in light pink. The blue is nice. The navy is nice. And then there's this other cool sweatshirt. The mug is cool. It's got that on one side. It's got that on the other side. And is that the big mug? I'm not sure. I don't think it's the biggest mug. I like big mugs. There's this water bottle, which is like pink sparkle. But again, I don't think the print is going to show up very well on that one. I may have to take it down. There's also this pink. So this is like this is a premium. They call this a premium hoodie. That's the front. That's the back. That comes in other colors as well. Just some fun stuff and things and stuff. All right, let's go to the comments. Thank you, Microdots, who says, what a difference a fair judge makes. Thank you so much. We talked about this. I don't know if D&E has cameras or signs that say that the cameras are recording outside. I just don't know. On top, thanks for being on top of the super stickers. Ryan said, Melanie, I love how it feels like you're making it into their arguments. It may not be the case, but that's how it feels. I feel like we have like telekinesis sometimes. Yesterday during the hearing, it was wild. I would say something and then it came out of Alan Jackson's mouth. Like it was crazy. And we do not communicate about this case at all. Brad says, Bradl and Alessi know how to play the game when it comes to the judges. Yes, they do. Thanks for the super chat. Learned Attorney Bederow, thanks for all that you do. Enjoy your content. Thank you so much for enjoying it. I enjoy having you here. Live, laugh, toaster bath. Thanks for your super chat. JFK has entered the chat. Yes, it is now a motorcade. It's a motorcade, not a rolling rally. KMAX says, can we file a missing person report for Madam Court Reporter? Where did she go? What did they do with her? Hashtag milk carton. Has Madam Court Reporter not been in the Karen Reed courtroom? I didn't notice that. I didn't notice it. Glamasu says, witness intimidation victims of Aidan are Matt and Jen McCabe, Brian, Chris and Colin, and Julie Albert, Julie Nagel, Mike and Lizzie, Michael Proctor and his wife, and Yuri Buchanan. Thank you. So those are the people whom the Judge Doolin this morning said he needs to stay away from them and their places of business. But he does get to attend the Karen Reed trial, and he gets a 300-foot curtilage to get into the courthouse. Yes, let's take a look at this. Let's take a look at this Sleepless Sleuth. So this is interesting. Christina Rex posted yesterday that she had a conversation with a juror who was chosen as an alternate in the end, and that she's an attorney. Did you guys see that already? I'll pull it up, so we'll look at that in a second. Meeple Marcy is here. Mr. Burns from the Simpsons Steeples. Thanks for your super chat. Is it legal to record audio on a public sidewalk? That I don't know. I don't know. Because everyone's asking me that. Thank you. Orphan Methodology, with all due respect, I think your perspective is inverted. Thank you so much. I don't know the Massachusetts law on that. That's a great question. Forrest Dump points out that Dennis Miller is a great satirist. Yes, he is. Everyone, please smash the like. We've got over 6,000 in here and only not even half the amount of likes. So some people, forget. But it is kind of like, wiping your feet on the mat when you come into someone's house. You just smash the like as you enter. Thank you. Piney Woods, thank you so much. Says, y'all will be my soundtrack for the biggest surgery of my life at the end of the month and for 8 weeks following. Oh my goodness. Well, we wish you all of the best healing vibes, and I'm sure you'll remind us again. Thank you for you thanking me for the privilege. I thank you. I thank you for the privilege. No, thank you. Free Karen Reed. Andre, sure. Thanks for your super sticker. Buck Francis became a member. Welcome. Click and Droppings just ordered a free Karen Reed shirt. Can't wait to get it. Thank you. Buck Francis, thank you for your super sticker. Bukalove says, I was the one who took the picture of McCabe's car at Proctor's house. Well, I don't want to dox you or out you, but I guess well done to you, right? Angie's Wave says, thanks, Mel. On lunch break, are we right side up or upside down? I don't know, but there's 2 Dave Matthews posters behind me, so I get the lyric reference. Am I right side up or upside down? At this point, I don't even know. I could be inside out at this point. Here is Christina Rex's tweet from yesterday, and it says, this is the statement released to me by Victoria George, an alternate juror from Karen Reed's first trial. She's also an attorney and has given me permission to share the statement, which is her reaction to today's hearing, as well as her name. Victoria. Victoria, call me. They're going to come for you. Just know that they're going to come for you. You're a lawyer, so you're probably prepared for it. But, if you want to come on, talk to me. You don't even have to show your face. You could just be audio only if you want, because I'd like to know what you thought, because we've only heard from Ronnie so far. She says to Christina Rex of WBZ, it was a fair-minded juror who left this trial questioning the integrity of the system long before the defense filed a motion to dismiss with allegations of jury tampering. And she's talking about the motion that was just filed after she was a juror. That was just filed like now. It is the Reed case itself and the fact that it is still being brought that has left many in Massachusetts wary, distrustful, and scared of our system. As a lawyer, this reality saddens me even more because I remember how much faith I had in our system as an optimistic law student. So true and sad at the same time. She goes on to say, Mr. Brennan made an impassioned argument today regarding his alleged concern that some might be questioning the fabric of our entire judicial system. If he would truly like to address that problem, I have a few suggestions. Perhaps the Norfolk County District Attorney's Office should be more focused on remedying the systemic issues plaguing it and affiliated police departments rather than continuing to spend millions of taxpayer dollars prosecuting a case with so many evidentiary issues that it calls into question whether they are even following their ethical obligations as prosecutors. Well done, Victoria. The Commonwealth has a duty to protect the rights of defendants, and I, for one, would love to see them do so. Wow. Makes you wonder, don't you think? Isn't it ironic, don't you think, that Victoria was chosen from the bingo drum to be an alternate in this case? If Victoria was on the jury, do you think she would have been able to convince 11 other people to acquit Karen Read on all charges? Do you think we would still be here today? Do you think this case would be over by now? I think so. I think so. Be not afraid, Victoria. Be not afraid. Somebody sent me somebody sent me what looks like a certificate of organization from like the Massachusetts Corporations Division, which indicates that perhaps Colleen Crawford and John Fanning are in business together. When was this thing filed? Hold on. And I can't vouch for its authenticity. So it looks like it was filed on the certificate of organization in 2019. Oh, and then they dissolved their business. So they may have been in business up until 2/2/22, but I cannot confirm or deny. Kendra says, right after Bradl says, get your ducks in a row. Yesterday, Cosgrove said, you can use Mr. Kearney's. Thanks, Kendra, for your super chat. Michelle says, we all know Melly's Beth, a lawyer person covering the Read case. How about a sweatshirt saying, nothing to see here, free Karen Read? Hey, I'll allow it. Nothing to see here. Susie, CJ, thanks for your super chat. Susie, thanks for becoming a member. And Crash Daddy's Cannon says, thanks for covering Turtleboy's case. Most of LawTube won't. They have become inextricably intertwined. And so while I tried to, when I wanted to get people interested in the Karen Read case, I didn't really know who Aidan Kearney was. And then when I started to learn who he was, it became kind of evident that some people just really were turned off by him. He knows that. That's not a shock. And so initially, I didn't cover it because I wanted people to come into this case and learn about it without being potentially not wanting to learn about it. A. Timothy Kearney did it. Aidan was framed, said Hans Gruber. But then there comes a time when the blind man takes your hand and says, don't you see? That is, name that Grateful Dead song. And they became inextricably intertwined. And so that's when I started covering it, covering the hearings. I know you guys want to watch it. You want to hear it. And so thank you so much. Cheryl Cave says, I got a picture in front of D&E on the curb by the street for 2 minutes. They called the cops and gave us the finger. I'm 71. My friend is 55. They're looking for people to charge. Yeah. Yeah, Cheryl. I think they are. I think 100% they are. Don't you? That's insane. And then Amelia said again, Rafferty's statement doesn't say the FBI is closed. I don't know if it says that or if it says that it is going to close. So without pulling it up, and I don't really know where it is right now. So I don't know. This is a great question. Boston Mass 781. Could Bradl have waited until the judge ruled before accepting the restrictions? It's almost like he prematurely made the judge's decision for him. I think he did a smart thing. I think he did a smart thing because he said, we'll just agree to this, Your Honor. Right? Because look, he could have said, you're now in violation of your other and throw him in jail. Right? He could have said, we need you to post another 10 grand, 1,000 cash. So there were some harsher remedies or penalties that Cosgrove wanted. And I think it was very smart of him to say, here's what we'll agree to, Judge. We'll consent to this. So I thought that was a smart thing, in my opinion. Right? I thought it was a very, very smart. Right? Robin says brilliant, in fact. And then pushing the limits of my medication says I'm not a fan of Turtleboy, but I will give him his dues when it comes to what he's done for the Karen Reed case. Yeah, I agree. All right, let me see. And Sandra, you got credit for that. Sandra got credit for sending me that information that perhaps at one point in time, Fanning and Colleen Crawford may have been in business together. And that's wild and crazy. Wild and crazy, not just wild. And she says that it was posted on the Justice for John O'Keefe group. I am not a member of that group, so I can't see what's in it. But for those of you who are, you can go take a look at it. And says they closed the business the day after the car was towed. Yeah, it looks like 2/2/22. Interesting. I don't know what to make of it. Let us see if there's anything else that I need to address before we wrap on this. And then who knows what could happen in Karen Reed today. Justin, thank you so much for your Venmo. Says Yannetti at the end of the hearing yesterday was brilliant. I agree. All right. Thank you to the moderators for keeping it classy today. This might even be a more difficult case to cover in many ways than Karen Reed because the trolls are out in full force. And so I thank you with all of my heart. Thank you so much to everyone out there for watching and for joining and for being members. And you're super cool. And I love each and every one of you with all of my heart. If I don't see you soon, I'm going to die. It's Clemens's meatball scene from The Godfather. If you know, you know. Make sure you have the notification bell set to all so that you'll know when I go live. If anything pops on the Karen Reed case today, like documents and filings, we are going to, we're going to uncivil art. Do you have a stream set up? I can I can redirect you if you're going to have a stream set up. Oh, there, look at that. Great minds. Do you have a redirect set up so I can do it? What are you going to cover? What are you covering? Okay, cool. Hang on one second. I will do that. Well, we're going to do a cupcake invasion over at Uncivil Law because, first of all, he asked nicely. Second of all, we don't have any beef, even though people want to create beef between us. Third of all, he's wicked smart. He knows a lot about the law, and he thinks the Karen Reed case is just as insane as we do. So let me just see if I can set that up. And then, Kurt, maybe you can tell me, like, I got so much stuff plugged into my laptop that I need, like, I don't know, do I need like some kind of external like thing to plug everything into? Because here it is, exclusive. Federal court double jeopardy transcript revealed. Oh, did you get it? Because when I went on Pacer today, it says it wasn't going to be released until like a couple of weeks from now. So he's got the federal court double jeopardy transcript. Good on you, Kurt. Good on you. All right, we're going. Cupcake invasion. Yeah, USB. Well, I've got like the dongle thing that plugs into my laptop, and it's got like 6 things plugged into it. And then I got the Ethernet plugged into the other one because I'm using a MacBook laptop. And so I don't know if I need like one of those like streamer portals that you plug. I don't know. I need a tech department, a whole full-on tech department. Thanks for your super chat. We are going to do a cupcake invasion on Kurt. Stay cool, stay kind, stay classy. I love you with all of my heart. Peace, my friends. Cupcake invasion. Safe travels in 3, 2, 1.